So good morning, everyone. My name is Mary Copeland. I am the owner and founder of Compass and Clock. What is Compass and Clock? Oh, glad you asked. It's a magazine that I publish twice a year, spring and fall. This is the spring cover for the spring issue, and it's free. Everything we do for Compass and Clock is free. This is one of our annual events. It's called The Road Ahead. Normally, we do this in person at the end of September. But due to COVID this year, we transitioned to online, to Zoom. We have been hosting Zoom seminars since Tuesday. We do 2 a day. There'll be 6 in the total series. The one that you're with us today on is called Estate Planning After the Secure Act. So it's about IRAs and how they work now that went into place January 1st of this year. Our presenter will also be talking about veterans benefits. And in addition to the seminars, we were going to do a fashion show, which did not translate to Zoom. So we hired a videographer and we did our fashion show. The theme is travel. So how to travel with less and not have your luggage rule your trip. Because it did our trip when we went away as a family in December. It was horrible. So it's a very fun short video, about 10 minutes. Tony, the presenter, and myself and a few other members of Compass and Clock were the models. And it's just showing you how you could pack a smaller bag so you can get around easier, and how you put less items in it, yet you create more outfits. So definitely go to the Compass and Clock Facebook page to view it. It went live yesterday. Our presenter today is Tony Hinson. He is on the call with us. That's Tony waving. Tony is in a car right now. He is not the driver. And Tony is an attorney, an elder law and an estate planning attorney with a lot of specialties in his background. Definitely an expert on the topics we are going to discuss today. He's a partner at the Sherrard McGonagle Tizzano Lind law firm in Poulsbo. And I am going to ask that everybody go on mute so that we have the best audio. And if you have a question, you can just chat me through the chat bar or unmute yourself to ask the question, but maybe using the chat bar would be best. I'm going to do the screen share for the PowerPoint for Tony. So Tony, why don't you say hello, introduce yourself, and I'll get the PowerPoint set up for the first meeting.
Fantastic. Well, good morning, everybody. And in the spirit of the road ahead, I'm taking the road ahead out to the coast this weekend. So thank you for joining, and I apologize for the audio. I hope that everyone is hearing okay. I cannot see the chat on my
Is it just me, or is Tony's audio?
Retirement plans today. Say again?
I said, is it just me, or is Tony's audio not working well? Like you just froze. Can everybody hear?
Can you hear me now?
Yes. Can everybody see the screen share that I put up?
Okay.
Okay, got it.
So just scroll on to the next slide there, Mary. So this is the standard disclaimer screen that you've probably gotten used to. I'm going to turn my audio off so I can speak directly into my video off so I can speak. There we go. Can everyone hear me a bit better? Is that better, Mary?
That is 100% better. Thank you, Tony.
Excellent. So the slide you're looking at now is the standard Weasley attorney disclaimer slide. But in this context, it's extremely important for 2 reasons. One, IRAs and retirement plans are very, very specific. And so planning for them does require you to work very carefully with professionals. The second point here is this is an area where it is critical that your attorney, your CPA, your financial planner are all communicating so that we're not working at cross purposes and we make sure that these IRAs flow in the correct manner. Next slide, please. So my background, I'm actually a Tennessee native, transplanted to the Pacific Northwest, so I'm here by choice. My wife and I met in the Navy. We moved up here on her orders, fell in love, and so we are in the very corner of the country, pouting up here, but a beautiful area. I went to University of North Carolina Law School. I have about 24 years in the Navy, both active duty and retired. Reserve. Retired in February, so very happy to have a bit more spare time to do things like take trips out to the coast. And I worked about 9 years with the IRS. So my hope is that the Navy service kind of balances out the IRS service and still makes me a good person. So I think we're all good there. Married to a Navy JAG. We've got 2 kids. We're all 4 here in the car together. And thank you for joining us for this presentation today. Next slide, please. So legal advice today is free. So you don't even have to pay 5 cents for it. Next slide, please. So how do we get here? What are IRAs? They've been around so long that we often forget where they came from. And they were part of the ERISA Act way back in 1974. It was Employee Retirement Income Security Act. It was before Congress really got on the ball with some catchy acronyms. So we're kind of stuck with ERISA. And in some ways, this was the first salvo of moving us from a defined benefit plan, the old company pension approach, to the defined contribution plan that we're now living under with 401ks and IRAs, where you save for retirement as opposed to having a guaranteed pension. The IRA was kind of tucked in there as an individual savings plan that was a complement to the 401k in a lot of ways. And so for many years, for the next 7 or 8 years actually, it kind of languished on its own and didn't get a lot of attention. The Tax Relief Act, Economic Recovery Act, of 1981 really moved it into its own, decoupled it from the 401k. The Tax Recovery Act of 1986 allowed limited contributions even when you had an employer-sponsored plan. So that's when you really saw IRA contributions begin in earnest. RRA 1997 introduced the Roth IRA. EGTRRRA of 2001, as you can see, Congress really only got on board here lately with good acronyms, allowed for indexing, and so we went from that old $2,000 limit up to an indexed amount that you can contribute, and in some ways that really began the growth of IRAs. And then finally, the Abuse Act of 2007 allowed for bankruptcy protection for IRAs up to $1 million. Next slide, please. They become a much more significant part of estates. When I first started with the IRS, I would look at relatively large estates, and there might be a $50,000 IRA, a $100,000 IRA, and we're talking about estates of several $1 million. So the IRA was really kind of an afterthought with a lot of people's economic planning, really until the last few years. As you can see from the stats there, it's more than doubled in the past 10 to 15 years, the amounts held in IRAs and the amounts held in retirement plans in general. So what we found in the estate planning world is that whereas we used to kind of forget about the IRA to an extent, make sure your trust and will was properly set up, really planning for the IRA and making sure that you've got beneficiary designations in place has become more and more critical. Not subject to estate creditors when passing to beneficiaries. They don't pass under your will. So that's the most important takeaway from today, if nothing else sticks, is that it is absolutely vital that you have beneficiary designations in place with your IRA custodian. Nothing you do in your will, nothing you do in your trust is going to directly affect where that IRA goes. It is going to be dictated by the beneficiary designation. So if you want some homework over the weekend, take a look at your IRA documents and then give your folks a call next week and make sure that your beneficiary designations are in place. IRAs do enjoy creditor protection. Thought there is that if someone does go through bankruptcy, we still want their retirement to be relatively secure. And so IRAs enjoy pretty robust creditor protection and in fact pass to your beneficiaries free of your own creditors in most cases. We'll talk a bit about their creditor protection in the hands of a beneficiary a little bit later. Next slide, please. And roll on to the next slide. So some critical dates: when somebody passes away, the clock does start ticking. Thankfully, you've got quite a bit of time in most cases to take care of where does the IRA go, who does the IRA go to, and how does it pass. I'd say the most important date is September 30th of the year after the person has passed. So if someone dies relatively early in the year, you can have well over 15 to 18 months to do anything with the IRA. If someone passes in November or December, the clock ticks a little bit quicker. You've got 9 to 10 months really to take action. But by September 30th, we have to know who the beneficiaries are of the IRA. And as we'll see, we can do disclaimers and some other things that can affect where the IRA passes, but that needs to be in place by September 30th of the year following. By October 31st, if your IRA passes to a specifically designed trust, you have to produce that trust documentation for your IRA custodian, basically your broker or bank or whoever the IRA is held by. And then by December 31st of the year after the person passes, the RMDs, the distributions from the IRA, have to begin. Next slide, please. So I've told you about designation of beneficiaries. What are good beneficiaries and what are bad beneficiaries? Well, the IRS calls these permissible designated beneficiaries and non-permissible designated beneficiaries. Basically, permissible designated beneficiaries are any individual, any real person, your spouse, your kids, your cousins, your uncles, your aunts, your parents, somebody, some living person who you designated as a beneficiary. Works really well. And the other type of permissible designated beneficiary is a specifically drafted trust that is drafted to receive an IRA and allow for the distributions from the IRA to fall through. What that means is that we don't look at the trust to be the beneficiary. We're allowed to look through the trust to the beneficiaries that are actually people when we decide how fast the money has to come out of the IRA. So what are non-permissible designated beneficiaries? Well, the most important classes are your estate, in quotation marks, or just your typical run-of-the-mill revocable living trust. And as we'll see, when you name your estate or your trust, that can create some income tax adverse consequences. It can really result in an accelerated payout from the IRA, so you lose all that tax-free growth inside of it, and it can result in income tax as the RMDs come out much more quickly as a result. Now, charities are non-permissible designated beneficiaries, but as we'll see here in a few minutes, they're excellent beneficiaries for IRAs, particularly traditional IRAs, if you have charities in your estate plan. I'll stop here to see if there are any questions. Mary, have any popped up?
No questions at this point on the chat. Does anybody have a question? Let's continue.
Okay, let's roll ahead. Next slide, please. So, in the good old days, and that's defined as anything prior to January 1st of this year, the rules for inheritance were pretty liberal if you named actual people. First of all, IRAs that pass to a spouse basically are eligible for what's called a spousal rollover. Your spouse becomes, for all intents and purposes, the owner of that IRA. It's as if they had set it up, they had earned all the income that went into it. Their age dictates how fast it has to come out. It may start coming out in 59 and a half. It has to start coming out at 72. And so there's no real change with that. Spouses are a special class. If an IRA passed to a non-spouse beneficiary prior to this year, then that beneficiary had to start drawing from the IRA, regardless of their age, the year after the person had passed. The good news was they could use their lifespan IRS tables to dictate how fast that had to come out. So if you left an IRA to someone, say in their 30s, they had over 40 years to draw that IRA down. So they could take 2.5%, then 2.7%, then 3%, just a really slow drawdown. And in most cases, at least in the early part, the IRA is earning more than that. So even though the person was taking money out of the IRA, it would continue to grow. This was known as the stretch IRA, and it was a very powerful way to leave an IRA to a child. You basically left them an annuity for their life. So old rules were you have to start drawing at 59 and a half, or sorry, you could start drawing at 59 and a half, and you had to start drawing at 70 and a half. Roth IRAs, there is no required distribution for the owner, but the same rules applied for non-spousal beneficiaries. They had to start drawing out of it the year after death, but they could slow down the withdrawals significantly. Then, next slide, please, along came the Secure Act last year. And this is a really cool graphic when I'm driving it. There's explosions. Imagine there's explosions behind him. Everything changed as of January 1st. Next slide, please. So as you can see, Congress has really upped its acronym game. So this was the Setting Every Community Up for Retirement Enhancement Act. They worked hard, but they got the Secure Act out of that. What the good news was, it raised the age that you have to start drawing from an IRA from 70 and a half to 72, as long as you weren't 70 and a half on January 1st. So it gives you another year and a half before you have to start drawing from an IRA. And the other significant change was that if you are still employed, if you're still earning income, not passive income, but actual wages, salary, hourly wages after age 72, you can still continue to contribute to your IRA. So that's the good news. The other good news, spousal rules did not change. So a spousal rollover is still effective. The spouse becomes the owner of the IRA, no change there. The big takeaway was that the stretch IRA was ended. So no longer could a non-spousal beneficiary use their life expectancy to draw down the IRA. Now instead, the non-spouse beneficiary has 10 years to take everything out of the IRA, even a Roth, from the time the person has passed away. We're still not certain exactly. Does that mean you have to take it out over 10 years, or could you wait until year 10 and take it all out? The act was drafted a little bit quickly and a little bit sloppily, so the IRS is going to have to come out with some guidance to tell us exactly how that works. So for now, if someone inherits an IRA and they're not a spouse, probably tell them to stand pat and see what happens. Next slide, please. Now, there are some exceptions to that 10-year rule. The Congress recognized that in some cases, we still want to allow people to use their measuring life. So if a surviving spouse receives an IRA, they can elect to use their life expectancy to draw the IRA down. That can be important for a spousal trust, as we'll talk about here in a couple of minutes. The most important aspect is someone that's less than 10 years younger, or minors are also exempt from the rule. The person less than 10 years younger is pretty obvious because the RMD schedule is going to stay almost the same anyway. A minor can wait until they're 18. They can take very tiny distributions until then using their life expectancy. And then when they turn 18, they've got until age 28 to draw the IRA down. The most significant exceptions, though, are people that are either disabled or chronically ill under the Internal Revenue Code. So special needs trusts and supplemental needs trusts are still good beneficiaries for an IRA. We're still allowed to use the life expectancy of the beneficiary to determine how fast things have to come out of the IRA. And we're still allowed, that still can qualify as a supplemental needs trust, which Richard went into quite a bit of depth on Tuesday. And that's a planning tool you would use for someone who is eligible for Social Security or eligible for Medicaid, and you don't want to remove their Social Security, their SSI eligibility, or their Medicaid eligibility. We still don't know, the rules for who is chronically ill or disabled are not exactly what the Social Security rules are under the Internal Revenue Code, but my guess is this is not going to be a high audit area for the IRS, so we'll probably just stick with using the traditional rules for that. So, and finally, anyone who takes subject, who is a beneficiary of a beneficiary, takes subject to the same 10-year rules. So you can't stack those 10-year rules out, unfortunately. Next slide, please. So how about Roth IRAs? Those are a very popular tool. They're great tools to have. Next slide, please. So one possible way to plan around the Secure Act a little bit is to do a slow roll Roth conversion of your traditional IRAs. So what you're doing there, particularly if you think you may have a taxable estate, is you are converting what will be income tax to, in a lot of cases, your children. You are accelerating that conversion and you are paying the income tax to convert it over to a Roth IRA. So in a way, it's an indirect transfer to your kids because you're paying the income tax during your life that they would have to pay after you passed if it remained a traditional IRA. So that can be a pretty powerful planning tool for larger IRAs in particular. Also, as we talk about in our life care planning seminar, if we're looking forward to Medicaid qualification, that slow roll Roth conversion is a very good idea, because then if we have to liquidate the IRA for someone who is going to be going into long-term care, there's not the huge income tax hit all at once. The final is you can consider a life insurance policy and kind of couple that with the Roth conversion, so that if you're not complete with your Roth conversion, that life insurance policy, the death benefit, can help pay for the income tax that's going to be due once the traditional IRA is liquidated. Next slide, please. Another opportunity, and this is for folks who have larger IRAs, they have a charitable part to their estate plan. There's a charity that means quite a bit to them and they want to include them. And they're a little bit uncomfortable with leaving a large IRA to their children. They're not exactly sure what they'll do with it. And they really like those old stretch rules. They like the fact that a child would receive a portion of the IRA every year. A way that we can make this happen even after the Secure Act is to set up a charitable remainder trust. That's a special type of trust that pays a certain percent of the trust assets to the non-charitable beneficiaries, like your kids, each year. And then at your child's death, in most cases, that whatever's left in the trust goes to a charity. Two really good parts about a charitable remainder trust. One, your estate gets a charitable deduction for the value of that remainder interest when you pass on. So you get a small charitable deduction in some cases. And the second most important part of these, charitable remainder trusts do not pay income tax. They pass income out to their beneficiaries who are not charities. So when the IRA pays to the charitable remainder trust, imagine it goes into a building and then the IRA explodes. It pays out, but all the income stays trapped in that building. So nobody pays income tax on it then. Now, as your kids receive the payouts from the charitable remainder trust, that income comes out to them and they pay income tax on that. But that looks a lot like a stretch IRA, because when the IRA would pay out to your kids in the old days, they would pay income tax on that. So this charitable remainder trust is a really good tool to kind of duplicate what a stretch IRA used to look like even after the Secure Act. And then at the end of that, when your child passes on, or at the end of a term of years, the charity takes whatever is left in there. Charities don't pay income tax, and so whatever income is trapped in there goes directly to the charity, and they get a dollar for dollar payout from the IRA. The downside is that your child can't pass the IRA on to their kids, and they can't get to the amount in the charitable remainder trust if they want to or need to. We normally use a 5% payout just to make these things work over a long time span, and so your child is limited to that 5% payout. Next slide, please. Oh, sorry, next slide, please. So, permissible designated beneficiaries. So if they're
Something's going on with your audio.
Generic trust. So, can you hear me now?
Yeah, we were losing you though.
Are we good now?
Okay. Are we on?
Okay. Yeah, we're getting into Mason County. So
okay. You asked me to change the screen.
That's the right slide right there.
Okay.
That's correct right there. So the takeaway from this slide is that we can use trusts that aren't charitable remainder trusts in IRA estate planning, but they have to be specifically drafted. If you leave an IRA to a trust that's not specifically drafted to receive it, then you trigger what we call the ghost RMD rule, which means that the IRA, in most cases, pays out per the decedent's RMD schedule. Now, without going into too much detail, that actually opens up a couple of planning tools going forward that we may be able to take advantage of after someone passes on. Again, because the Secure Act was not that well drafted, we may be able to use that to lengthen the payout in some cases. But specifically designed retirement trusts allow us to look through the trust to the beneficiaries and draw the IRA down according to their life expectancy or according to the 10-year rule if we're dealing with an IRA going forward. Next slide, please. And next slide, please. So, to know that there are two types of IRA trusts. One is called a conduit trust, and that's just a fancy way of saying that the RMDs that pay out of the IRA, the required payments, pass directly to the beneficiaries. They touch the trust and then hop right out, just like a lily pad. And so the trust is a conduit for the RMD payments. And those are very powerful because the trust is not going to be paying income tax on the payments. Those will pass directly out to the beneficiaries. Next slide, please. So how we can use a conduit trust even after the Secure Act, if we've got a large IRA in an estate, and that's the dominant asset, and we would like to be able to move part of that IRA out of the estate of the second spouse, because otherwise we might end up with a taxable estate there. But we also want that spouse to have the benefits of the IRA. We don't want to leave it to children or some other beneficiary to take advantage of the credit of the first spouse. Then we can leave it to a specifically designed trust where the spouse is the trustee, the spouse gets the RMDs from the IRA, the spouse can take additional distributions for health, education, maintenance, support. They basically get to continue their lifestyle, but that IRA is not in their estate when they die. We can use a conduit trust to do that. And if you remember, a spouse was an exception to the 10-year rule, so we get to use the spouse's life expectancy to dictate how fast the IRA comes out. And unless the surviving spouse is in their 90s, their life expectancy is always going to be longer than 10 years per the tables. And so we can stretch out how fast that IRA comes out after the person passes on. So marital trusts using that conduit trust model are still available after the Secure Act and can be an excellent way to use the first spouse's estate tax credit, even if the IRA is the large asset in the estate and we want the surviving spouse to be the beneficiary. Next slide, please. Now, accumulation trusts are another type of IRA trusts. As you might guess, they accumulate the required minimum distributions. They still pay out per the beneficiary's schedule, but the trust is not required to pay them out. So this is an excellent vehicle for a supplemental needs trust for someone who is trying to qualify for SSA or SSI or Medicaid. Now, typically you want to pass income out of a trust because they pay the top marginal rate at $12,000 of income. So they pump up to the top marginal rate really. But in most special needs trusts,
we're totally losing you, Tony. 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 Hello. Nope. You might need to pull over. Tony. Let's give him, I know you're trying. I think he's going to have to call us back. He just dropped off the call. But that's okay. We're all still here. So Tony will be back with us in a moment. Does anybody have any questions at this point? So when Tony gets back on, we can have him answer the questions. No questions, anybody?
No, I have a question.
Sure, what's your question, John?
Right now, my wife and myself are over 70, and we pay a required distribution of assets, stocks, I guess IRAs, basically. Would any of this affect that requirement? And would it lower the required distributions?
So if I'm understanding you
Can
properly,
you hear me?
yes, talk again though, so I can see if I can hear you better. Tony? Don't hear you. I don't even see that you're on. John, I just muted you. Could you unmute yourself for me, please?
Yes, I'm unmuted.
So my question to you is this, John, is your question saying that you and your wife are over 70 and you have IRAs? Are they traditional IRAs or Roth IRAs?
We have both. Of course, we don't pay on the Roth, but we do pay on the.
You mean as far as taxes go?
Yes.
So is your question asking, you're saying you pay yourselves the required distribution each month or each year. And your question, I believe, is, are the new rules that went into place with the Secure Act going to affect what you're doing?
Correct.
And we will have Tony answer this, but
So can you hear me now?
we can. I hope you pulled over because you just have a few slides
Okay.
left. So John has a question. Hello?
Okay, I got the question, absolutely. The answer is if you were already 70 and a half, you're already 70 and a half,
Tony, your reception is not working. So we need to figure, I don't know, can you get to a spot where you can stop driving for 20 minutes and finish up?
trying to do
Hello? Tony?
this. Yeah, okay, I can hear you. We're trying to
You can hear me, but we're having a very hard time hearing you. So maybe you have the PowerPoint printed out? Hello? We've got a few questions here for you. So John, for you, it sounds like, were you and your wife older than 70 and a half years old this past January? Just give me a thumbs up or a thumbs down. Just raise, were you older than 70 and a half in January?
Yes.
Okay. Then I think there's an exemption for you then, which means that you won't have to do it in the 10 years that is now required. That's my understanding. Hopefully we can get Tony back so he can finish this seminar, because we've got other questions and it's really great information, but we're dealing with a few technical difficulties. So
what you said a minute ago sounded wrong to me.
so what I just said is wrong. I know Tony was saying when we had him for one split second, depending on your age. So right now we're on slide 71. So let me go back. And 70 and a half come January was applies to those who turned 70 and a half after January 1st. So increases age to traditional IRA contributions after 70 and a half earned income rule applies. So the 70 and a half has to do with if you didn't turn 70 and a half until after January 1st, then your required minimum distributions don't have to start until the age of 72. They don't have to start at 70 and a half. So I would think, and Tony will have to confirm this, but it sounds like the 70 and a half just has to do with when you start your RMDs. I think exceptions to 10-year rules, surviving spouses, individuals, 10 years. I think you're going to be subject to having to finish your RMDs during a 10-year time frame. But Tony will have to tell us that.
Wrong.
Oh, Mark, go ahead, help me out.
I don't think there's anything in here today that changes the RMDs for John.
Yeah, only for my
His
kid.
lifetime. I mean, after he's dead, yes, it changes it, but during his lifetime, it doesn't change it.
Yeah.
Unless I misunderstood his question.
Well, hopefully we can get Tony to get back on.
Do I have good audio now?
Yes, you do.
Okay, the answer to that question, no. If you were drawing from your IRA as of January, you will keep the same RMD schedule. That said,
We're losing you again, Tony. Everybody, let's make sure we're on mute.
okay, I don't know if this is good because we're trying to get to another good area and we're not finding one.
We're going to be in Shelton in about 9 minutes.
I can hear you right now, Tony.
Can you hear me now?
Yeah, so just don't move. And we have a few more questions for you too.
Right.
So I can hear you. Should I
Okay.
ask you the next?
We're gonna pull. We're trying to pull over, so hold on one second here.
Okay. Thank you, everybody, for your patience.
Absolutely. I've never seen such a long video as this. So, am I still on?
Yes.
Okay. So, the CARES Act removed the requirement for an RMD for 2020. So, if you're not taking your RMD for this year, you don't have to. So, what were the other questions?
And we're going to have to fix your audio somehow. Are you talking into your phone or are you on a headset?
I am talking in my phone. Can you hear me?
Yeah, we've got static. But the next question is, does someone who is already stretching an inherited IRA, are they subject to the new Secure Act provisions?
No, if the Secure Act had a grandfathering provision so that if you own an inherited IRA, then that's great. You've got a stretch IRA and they are a dying breed, so that's a good thing. You do not have to go to the 10-year payout. You still continue to use your lifespan.
Okay, the last question is, I'm recently retired. Is there a reason to move a 401k to IRAs?
These are awesome questions. So from my side of the fence, the estate planner side of the fence, I would much rather see you in an IRA than a 401k. The reason being 401k distributions are dictated by the 401k contract. Once you convert it to an IRA, you come under the IRA rules, which are often much more liberal, even with the 10-year payout. So the reason, I would talk with your financial advisor. If the 401k is able to invest in very special stocks that are not available to the public, that's a good reason to stay. If you're still working and still subject to a match, then absolutely stay in the 401. Otherwise, talk to your financial advisor. In a lot of cases, most cases, it makes more sense to convert it over.
Okay, let's continue. You were on slide 21, accumulation trust, and I asked you all the questions we had so far.
Okay, so, and accumulation trusts offer great creditor protection. The general rule for creditor protection is the creditor can get to what you can get to. So if your beneficiary has no right to distributions, then the creditor of your beneficiary has no right to distributions. So these accumulation trusts can also be pretty effective for beneficiaries who aren't that great with money or potentially have chemical or substance abuse problems. We've used those as well. If they're not chronically ill or disabled, they're subject to a 10-year payout still, but you can still control how quickly they get it with the trustee. So these accumulation trusts have limited applicability outside of the supplemental needs trust, but they're pretty powerful. Next slide, please. So I'll go through this slide pretty quickly. Creditor issues, IRAs. Your own IRA is fairly secure from your own creditor up to $1 million. IRAs in your estate passing to beneficiaries also enjoy creditor protection. So if they pass directly to a beneficiary, then they'll generally pass free of creditors' claims against your estate. We thought this applied to inherited IRAs as well until 2015, when the Supreme Court issued a rule in a case called Ramaker that basically told us that unless the state specifically exempts IRA from creditors, an inherited IRA, then the beneficiary of that IRA, the IRA is subject to their creditors. What happened in this case was there was a relatively wealthy beneficiary who received a relatively large IRA from her even more wealthy parents. She ran up quite a bit of debt, declared bankruptcy, and was sitting on top of a multi-million-dollar IRA and claimed that that was exempt from her creditors' claims. The IRA, or the bankruptcy trustee, disagreed and brought the case, and the Supreme Court issued the ruling. A funny takeaway from this one is that the beneficiary stayed in the Four Seasons in DC for the Supreme Court arguments and posted on her Facebook and Twitter accounts beautiful pictures of her gourmet breakfast that was delivered to her room the morning of the Supreme Court arguments, where she was arguing bankruptcy protection from her IRA. Unknown if that made it to the Supreme Court clerks or not, but just an example of social media can get you in trouble. Next slide, please. And next slide. So we can fix it. Even if there's some problems with an IRA post-death, we can sometimes do things even after the IRA owners has passed to fix problems that occurred during their life. Disclaimers are our most powerful tool. A disclaimer is a written document that you exercise within 9 months of the date of death of the person that basically has the IRA pass as if you died first. And so that can be helpful in moving an IRA down the chain. It can be helpful in moving an IRA over into a trust potentially, if we can disclaim our way into a trust. And in some cases, that opportunity actually ended yesterday, but we were able to work with a few clients to disclaim IRAs that passed at the very end of last year to get them down to kids so that we could take advantage of stretch rules. So there's some fixes we can do with disclaimers with the IRAs even after death. Next slide, please. So this this is a common problem we see, is that even if the IRA is intended to go to the surviving spouse, either the decedent or a financial advisor or someone else made that IRA payable to the estate or the revocable living trust. In a lot of cases, the spouse is the only beneficiary of the estate. The spouse has an unfettered right to the assets in the estate, and the spouse is the personal representative. And in those cases, the IRS has been fairly lenient with allowing the spousal rollover to roll through the estate to the spouse. They've issued a lot of what are called private letter rulings, which allow people to do that. And so unless the IRA is very large, we can generally do that without going to the IRS. If the IRA is pretty large, we may ask permission, but we can typically fix that problem and get the IRA directly to the surviving spouse which was more or less the intention all along. Next slide, please. IRAs and charities, I spoke about this initially. If you have a charity in your estate plan and you have a traditional IRA, that's a match made in heaven. So in a lot of cases, instead of leaving that traditional IRA, say to your kids, where they have to draw it out in 10 years and it's going to be income when they do, and you have a charity maybe as a partial beneficiary of the rest of your estate, we want our clients to move the charity over to the IRA. You have some or all of the IRA pass directly to the charity. IRA pays out to the charity. Charities don't pay income tax. You get a dollar for dollar distribution to the charity. Your kids, on the other hand, receive the other assets in your estate that aren't the IRA, so they don't have to pay income tax on them. So instead of having these percentages all around your estate, in some cases it makes sense to make the charity the only beneficiary of the IRA or the large beneficiary of the IRA. So that's a great opportunity that goes missed a lot of times. And so it's a great chance to increase your charitable deduction and increase the amount going to your non-charitable beneficiaries. Next slide, please.
I have a question. Is there a limit on the amount that you can donate to a charity in 1 year?
Well, what I'm talking about here is an IRA passing to a charity at your death. So no limit whatsoever on that. And we'll talk, actually, I may have taken the slide out, so let me speak to that. If you've got an RMD coming out of your IRA and you don't need it, and you would have made a charitable donation anyway, the problem with that is if the IRA pays out to you, it's a part of your AGI, your adjusted gross income. And then your charitable deduction is subject to the standard deduction limitations. So you may not get much benefit from the charitable contribution you make, even if you do it basically with the money you got out of your IRA. There is something called a qualified charitable distribution, though. You don't have to do it in 2020 because there are no required RMDs. You can if you want to. But in another year, you can tell your IRA custodian, don't send me the RMD. Send it directly to XYZ charity. And that's really nice because the RMD never touches your 1040. It's never part of your income. So if you're looking potentially being locked out of other benefits of having a lower income, or you want the full benefit of the charitable deduction, you don't want it to, you want it basically to come off your income, that's a great way to do it. It's called a qualified charitable distribution, and your financial advisor can work with you. And Carol had a question. What was that, Mary?
Carol's question is, my IRA goes to my spouse, or if he's gone, a charity. My confusion is that you mentioned IRA beneficiary cannot be a charity, and then she posed the question another way. My will gives my IRA to my spouse, or if he's gone, to a charity. So my understanding is IRAs need to be set up with a beneficiary on it, and if there's nothing on there and it's just in the will and it says my IRA goes to my spouse, that's not, it gets wrapped up in the estate.
Right. Once your IRA passes to your estate, it's subject to all the estate rules. So what you want is exactly what you've got set up. Your spouse is your primary beneficiary on the IRA, and the charity is the secondary beneficiary. A charity is not a permissible beneficiary in that it has, the IRA is going to have to all pay out very quickly if it's a non-permissible beneficiary, but the charity doesn't care because they don't pay income tax. So the way you've got that set up from what you're telling me is that it's on the beneficiary form, it's your spouse, and then the charity. That's good. So leave your, if that's what you want, I would leave the beneficiary designation in place that way. Don't name your estate because that's going to create some other issues for you down the line. Only though, if you've got your spouse listed as beneficiary of the IRA, and for some reason the IRA does pay to your estate, we can do that same spousal rollover I talked about a few slides back to fix that. So it sounds like you're covered in both cases there. So next slide, please.
There's a follow-up to this. Okay, I think she got it now. Okay.
Oh, I'm sorry.
Nope. the bottom line is you need to fill out the beneficiary forms. The will doesn't dictate where it goes. Right?
Yes. I'll reemphasize that. If there's anything you take away from today, check with your financial advisor, make sure your beneficiary form is in place. And unless your financial advisor is working closely with your estate planner, don't name your estate as your beneficiary. Make sure that those two folks are talking before you do that. IRAs and durable powers of attorney. So a lot of older durable powers of attorney do not have express IRA powers in them. And that has become a problem as IRA custodians have become more and more insistent that powers of attorney specifically address IRAs. A general banking power, general power over my financial assets used to be fine. We're finding it's not so much anymore. So a well-drafted general power of attorney, a durable power, will have specific IRA language in it, which will allow your attorney, in fact, the person you designated in your durable power, to work with your IRAs, to move your IRAs, to change beneficiaries. And you can specify in the durable power what are the beneficiaries that you will allow your IRA to flow to. Where this becomes significant is upon a second spouse's passing. I was working with a client who had a durable power of attorney drafted by another attorney over in Seattle, did not have the specific powers in there. And unfortunately, even though the IRAs were set up properly, the first spouse passed, IRA passed to the second spouse, the child was not able to set up beneficiary designations on that spousal IRA because of the limitations in the durable power. Now, we were able to fix that, but it would be much more effective if the power of attorney contained that language anyway. So we are careful in our office. We specify that. It's something we discuss with our clients to make sure that their durable power of attorney encompasses the IRA. Next slide, please. So I'm going to speak on veterans benefits. So we're going to change gears here for about 5 minutes. Veterans benefits that are of special interest to clients of ours are the three that are laid out in this slide. One is the service-connected disability. That is the one that most people are familiar with. It's a compensation and health care for service-connected ailments and service-connected illnesses. You will go through a VA check to make sure that the VA agrees that whatever you're suffering from was caused by your service, and you're therefore entitled to compensation and treatment. The range goes from 10% to 100%. It follows special VA math. So 40 plus 30 equals 50 under this math scheme, but you end up with a final rating. One thing I do want to cover on this deals with Vietnam veterans who are moving more and more and more into the retired realm. If a person spent 1 day in country in Vietnam, and that includes Navy vets who were in the territorial seas of Vietnam, and they come down with a list of ailments, and it's pretty extensive, available on www.va.gov, then their ailment is deemed to be connected to their exposure to Agent Orange. And this is a pretty broad range. It goes from certain types of diabetes to leukemias to Parkinson's disease, ischemic heart disease, basically hardening of the arteries is in there, skin ailments are in there. So a lot of diseases that people do suffer from, and Vietnam vets in larger numbers than we would expect, that is considered to be automatically connected to service, and the veteran is entitled to compensation and treatment for those ailments. Next slide, please. Oh no, stay on that slide, I'm sorry. So, sorry about that. So jump back, yeah. So service-connected disability, I call this a Bill and Melinda Gates benefit because it doesn't matter how much money you've got, it doesn't matter how much money you make. If you are harmed because of your service, you are entitled to compensation. That brings up another quick point. Veterans are notoriously bad about applying for benefits to which they're entitled. I think it's part of our ethos as being service members. We think someone else needs it more. We're not really entitled to it. We weren't hurt that badly. Please get that out of your head, get it out of your loved one's head, get it out of your friend's head. If they served, they're entitled to the benefits I'm talking about. They should apply. American people have decided through Congress, this is a good thing, and you earned it, you served. The next benefit I want to talk about is basic pension, homebound, and aid in attendance. This goes by aid and attendance with most people. What this is a benefit that is related to income and is related to wealth. Basically, your income needs to be below $26,000 a year, and you get to deduct medical expenses from that to get yourself down below that amount. And your assets have to be below about $127,000. That does not include your home. So your other assets have to be below 127. If those are the cases, you served on 90 days active duty, 1 day of which must be during a wartime period. And except for the 1980s, we've pretty much been in a wartime period since World War II. I'm not sure what that says, but that's the way we are. The periods themselves are specifically listed in the Compass and Clock magazine and on the Compass and Clock website. But if you meet those wickets and you need help with activities of daily living, you're homebound to your home, or you need help with an extensive number of activities of daily living, you can be eligible for basic pension. If you're homebound, you can be eligible for homebound. And if you need help with a lot of activities of daily living, bathing, brushing your teeth, preparing food, clothing yourself, just a lot of things that we take for granted but become challenges when we get older, you can be eligible for this basic pension. You do not have to be a retiree to receive it.
Really?
The last benefit I want to talk about is dependent indemnity compensation. This is another Bill and Melinda Gates. Doesn't matter how much money you got, doesn't matter how much money you make. If you are a dependent of a service member who either died on active duty, died from a service-connected disability, we'll talk about that in a second with Vietnam vets, was a POW and was rated 100% for 1 year, almost always the case, was rated 100% for 10 years prior to their passing, or died because of VA medical negligence, the dependent can be eligible for compensation. Where we're seeing this most often now are Vietnam vets who have passed of Parkinson's, who have passed of leukemia, who have passed of heart disease, and were in country for a day, or were in country basically for a tour. The dependents can be eligible for up to $1,900 a month from the VA. And the final word on this, VA benefits are tax-free. So the benefit itself, you can multiply it by another 20% to make it equivalent to a taxable pension. So there are very solid ways to plan for retirement to provide an additional amount of income for veterans. And if you know a veteran, you are a veteran, you love a veteran, please encourage them to apply. Next slide, please. So now we'll wrap up. I'm going to sign off here in a moment. Thankfully, we hit a good sell spot. But we're typically, Richard and I, our billable rate is about $300 an hour. We're offering, however, to folks who attend our seminars in an effort to get people in during this COVID time, we've reduced our charge for a 2-hour meeting is $100. If you sign up through Mary and through Compass and Clock, Mary has the special red phone right directly to our scheduler, so she can pop you onto our schedule. Love to meet with you, sit down, bring the documents that you've got. We'll take a look. In a lot of cases, some or all the documents you got are good to go. And we'll talk about some of the aspects of your estate plan, make sure you're comfortable. If you bring in documents that are on carbon paper and the pages stick together or they were mimeographed, we probably should talk about updating your estate plan, and we can talk about what that means and the documents you need at that point. So would love to sit down with you. If you're a veteran and need assistance, most of the initial application you can do right on the va.gov website. If you have applied and you've been turned down, I've got a Rolodex, to use an older term, of attorneys nationwide who handle VA appeals. I would love to hook you up with one of those folks. They can take your case on contingency, and in every case, that's what they do. They don't practice any other area of law. It's highly specialized. So would like to work with veterans, or veterans just have questions during our estate planning meeting. I'm a veteran too. I speak acronym, and we can talk about the benefits to which you're entitled. Next slide. So any final wrap-up questions?
I think what I would like to do right now, Tony, is stop the screen share and
Okay.
open up the floor for people to ask questions. So here we are.
Fantastic.
If you have any questions, you send them through the chat if you want. If you don't have audio, or unmute and ask Tony. We've got him for another 5 minutes. So ask away.
Wow.
This is Carol. I'd like to know how long
Oh, yes, ma'am.
$100 offer lasts.
I can answer that, Tony.
Sorry.
Carol,
Okay, there
when
you go.
Tony and Richard do seminars with me every other Tuesday, and they offer the $100 2-hour consult. So if somebody said they wanted to make an appointment, let's pretend today from this seminar, they would then set that up, but you might not want your appointment till December. That's okay. It's when it's best for you. So I hope that answers your question. John, ask what.
I'm intrigued by the idea of changing IRAs to Roth for my beneficiaries, kids. And you didn't speak very much about the rate of transference, or does this what kind of paperwork is required?
Great question. And this is an area where you want your financial advisor and your tax person working pretty closely together. So if you work through a CPA to file your taxes, you want these two people talking. So basically what you do to convert is you take money out of the traditional IRA and you roll it into a new account, which is a Roth IRA. Now, as you pull money out of the traditional and convert it to a Roth, that's going to be income. So you're going to want to do it in a manner that's most tax efficient, and that's why you want your tax planner working with your financial advisor to make sure that you don't take too much in one year and pay a higher marginal rate on it. A lot of times what they'll do is they'll take the distribution right up to the top of the bracket that you're currently in to take advantage of that. So that's truly an area where you want a team involved. You want your tax planner and your financial advisor working together. Otherwise, it basically is a rollover from your traditional IRA into a new Roth IRA account.
It could be an existing Roth also, right?
Oh, yes, yes, absolutely.
Okay, thank you.
We have another question here. George would like to know if you have any thoughts on law changes that might happen next year in 2021.
Well, that's a good question. So from an estate tax point of view, the current federal exemption is 11.6 million. That will stay in place unless changed until 2025, when it will spring back to 2017 levels. I know that Vice President Biden, as part of his platform, has proposed a $3.5 billion exemption, which would take it down pretty substantially. That would require Congress to pass that, so we need some kind of a democratic wave for that to occur. If President Trump wins the election and Republicans keep control of one or both houses of Congress, then likely that will happen, certainly. So there's a lot of changes going to occur, I think, in the next 5 years. It's going to tell us the estate tax planning side what we're dealing with. The current Washington exemption is 2,193,000, and because of a highly nerdy tax geek sort of reason, it's going to stay fixed there until 2025. And then it might change, it might not, depending on what Congress does. So it's kind of an exciting time in the estate tax planning world, because
I think we just lost him. Oh, there he is. He's coming back.
there's that. Can you hear me?
Yes.
Okay. So post-COVID and the CARES Act, I don't think Congress is going to do anything cost tax purpose. So we're probably stuck with the end of the stretch, at least for the foreseeable future. One thing that might happen in 2021, how the economy's doing, they might extend that RMD holiday to 2021, meaning that you might not have to take an RMD from your IRA next year. Keep your ear to the ground, and we'll find out.
I think at this point, since we've had some technical difficulties, it might be best if we let Tony go. I will stop the recording, and any questions that you have, I will get them typed up and sent to Tony, and then I will disperse them to all of you that are on the call. How does that sound?
Fantastic. And thank you everybody for your patience in the audio part of this. We just hit a dead zone there. Really appreciate everyone attending, and look forward to some questions coming in from Mary. So